Morning. Good morning.
Imagine.
I'd like to call us to order if I could. My name is Beverly Martin, and I'd like to welcome all of you on behalf of the Center on Civil Justice. We're delighted to have you with us this morning, and I think we're going to have an action-packed, intellectually stimulating day today. I'm not going to take up a whole lot of time with introductions because I want you to hear from the people I'm introducing instead of me. This panel is going to be moderated by Chief Judge Lee Rosenthal, who is the Chief Judge in the Southern District of Texas, a very respected and beloved judge, which is kind of a hard combination to meet sometimes. And she will be moderating the panel, including George Berman, who made a heroic effort to get here this morning. He is the Gellhorn Professor of Law and the Monet Professor in European Union at Columbia Law School. He is the Director of the Transnational Litigation and Arbitration. Is that
Close enough.
Okay, got it. I'm also going to introduce you to Benno Kimmelman, who is a counsel and an arbitrator in a broad range of international arbitrations. Thanks for being with us. And Carolyn Lamb, who is a litigation partner at White & Case, who has an enormous amount of expertise in the area of arbitration as well. So Judge Rosenthal, I'll turn it over to you. It's good to see you.
Good to see you too. Thank you very much, Beverly. And thanks to this distinguished panel for joining us. I'm sorry I can't be with you in person. I had every intention of doing so until back-to-back back surgeries left me here in Houston on my heating pad, Zooming with you. I wish I could share the fellowship more directly. Our panel is indeed distinguished. And I've always admired and sort of envied them because most of my conversations with them begin with them saying, I just got back from Paris or London or Amsterdam. Their lives are indeed full of the full potential of arbitration. I live in a somewhat more humdrum world. I deal with not only arbitration clauses that appear in very sophisticated transnational multi-entity oil and gas contracts, but also consumer contracts that have the boilerplate. You may not have known it, but you agreed to arbitrate, or employment contracts, many of which have highly contested arbitration provisions. We have a framework, but it is not a perfect framework, far from it. And arbitration provisions are often the subject of threshold litigation to determine, is this arbitrable, as to whom, and as to what? Who's bound, and what's the scope? Our panel is going to address some of these so-called threshold issues. Interestingly, if they don't appear at the threshold, it's kind of like the Amityville Horror. We're back. They reappear or appear for the first time after arbitration in efforts to vacate the award if one has been given. So let's talk about the framework. And I'd like to first turn to Professor Berman, and then Benno, and then Carolyn. What does arbitrability mean under federal law? George?
Yeah, is this on?
Yes.
It
Good,
is.
good.
For me, it is.
Well, I might as well begin by saying that arbitrability is not understood in the same way everywhere in the world. I think other than in this country, arbitrability means the legal capacity or ability of a particular category of claim to be arbitrated. And non-arbitrability is therefore a single, narrow, reason for denying enforcement to an arbitration agreement. Supreme Court of the United States uses the term far more liberally to include, well, maybe I'll give you some examples. I see many people in the room here for whom what I have to say is nothing new. So apologies in advance. I was told there might be some people who aren't familiar with the material, so that's the reason for my going over some familiar territory with you. Arbitrability in the Supreme Court sense of the term really means, is the tribunal endowed with jurisdiction, basically. Now, instead of speaking of arbitrability, the Academy and increasingly the bar uses the distinction gateway and non-gateway, and that's the term I'm going to use. So gateway corresponds generally to a jurisdictional issue, and non-gateway to what in other countries, not here so much, is called admissibility issues. So what are the gateway or arbitrability, using it in the American sense? There are essentially 5 of them, and the distinction between gateway and non-gateway, Lee, is essential to the discussion we're going to have. So I would say among those jurisdictional or gateway issues, we have at least the following. Was a contract formed? If so, was an arbitration agreement within it formed? If so, is the party either asserting the arbitration agreement or against whom the arbitration agreement is invoked to be treated as a party, even if a non-signatory? Fourth, assuming all the answers to the above are positive, is that arbitration agreement valid? And finally, as Lee said, assuming all of the above, does the dispute fall within the scope of the arbitration agreement? Now, in varying degrees, these issues, I think, do have a jurisdictional dimension to them. Frankly, if any of them is demonstrated to be missing or absent, the jurisdiction of the tribunal is seriously in question. We have to turn to non-gateway issues, which are more difficult to characterize. Those are threshold issues that we treat as non-jurisdictional, but if problematic, would nevertheless prevent an arbitral proceeding from going forward. And the most notable examples of those are the statute of limitations, waiver of the right to arbitrate, res judicata, and failure to satisfy preconditions to arbitration. And I hope you appreciate that the first set, gateway issues, all have a consent dimension to them. And these non-gateway issues, in principle, do not. If there's a statute of limitations problem, we have no reason to think there was no consent. Waiver of the right to arbitrate presumes consent, and then waiver. Res judicata, no reason to doubt the consent of the parties. I'll leave conditions precedent aside because there is some debate, I have to warn you, as to whether that should be treated as a jurisdictional issue or an admissibility issue. You only have to read the BG Group case in the Supreme Court to appreciate that. Okay, the second thing I need to say preliminarily, and familiar to most of you, is that the central case around which all the debates are taking place is the First Options v. Kaplan case. And we haven't time to go through them. Let me just say briefly, Mr. and Mrs. Kaplan challenged the jurisdiction of the tribunal, whose jurisdiction had been invoked by their broker. So they were respondent. They challenged jurisdiction on the ground that they were not signatories. The signatory was their wholly owned company. The tribunal nevertheless held that they were liable, even though non-signatories, liable to arbitrate. Even though non-signatories, they wisely preserved their objection. In the arbitration, they lost. They sought annulment. The district court upheld the award. The Court of Appeals reversed, and it went to the Supreme Court. That's the factual background of this case. Now, the holding of the court is fundamental to today's discussion. What the court said in a nutshell was that, and the premise is that whether you're a signatory or non-signatory is a jurisdictional issue. That's the premise of what the court said. The court said that consent to arbitrate is positively fundamental, that in its absence, an arbitral proceeding and the award that results lack legitimacy. The award is capable of being annulled, denied recognition and enforcement. As a result of its fundamentality, a party seeking judicial determination of arbitrability is entitled, if it wishes, rather than go to the arbitrator first, raise that question in the court. It will typically already be in the court because it will have brought an action in the court, and the arbitration agreement will have been raised as a defense, and the validity of the arbitration agreement will be called into question. And the court, through Justice Breyer, made it plain that not only is this a question that courts may address initially, if asked to do so, but that they do so independently, meaning they use their own full judgment without any anticipated deference to a tribunal that might follow. On the other hand, in the interest of party autonomy, which is likewise fundamental, the court specifically held, though it was dictum in this case, that a party may be found to have relinquished its right to independent judicial determination of gateway issues in the interest of party autonomy if the parties, and this is of course the key quote, clearly and unmistakably so-called delegated, that's the term used, delegated authority to determine jurisdiction primarily to the tribunal. Functionally speaking, this means that instead of being able to bring a gateway issue before a court prior to arbitration, you must bring it first to the tribunal. I will get to the rear end later, but we're still at the front end of this. Interestingly, rather than remand the case, the Supreme Court, based on the record before it, said that there is no clear and unmistakable evidence of a delegation, and more surprisingly, Mr. and Mrs. Kaplan are not bound. No remand on that question. You would think there might have been no remand on that question. Okay, the court had no occasion in that case, nor has it since, to give us clues as to what constitutes clear and unmistakable evidence of a delegation. All we know is that delegation is determined according to a highly exacting standard, an exacting standard. Now, in the majority of cases that follows, the issue arose pre-arbitration. First options was post-award. So most of our cases will be pre, and those cases have transposed. Those courts have transposed the thinking expressed by the court from the rear end to the front end. The district courts, these mainly in federal court, the district courts initially were somewhat divided. They were, in retrospect, one surprised given what the federal courts at the appellate level have had to say. but they were divided on this question. But every Federal Circuit Court of Appeals that has addressed the issue, and all have except one, I believe it's the Seventh Circuit, all have but one, have come to the conclusion, have told us that clear and unmistakable evidence is present on the sole basis, sole meaning not the only basis, but sufficient, that in the arbitration agreement, the parties adopted a set of institutional rules that contain what we call a competence clause. And the presence of a competence clause in the rules that the parties adopted, and I would say by extension in the lex arbitri, if it's there, and it is in the UNCITRAL model law. If that circumstance arises, there has been a delegation, and a court will not entertain objections to jurisdiction on the basis of gateway issues, which it ordinarily would in the absence of a delegation. I hope that's clear. Okay. Now, all circuits have taken that position, that have spoken. Interestingly, a few state courts have disagreed. Post first options. And there's a case was denied cert last year in which a Florida district court said first options is being misunderstood and misapplied by the federal courts. It was reversed by the Court of Appeals. There is now pending in the Supreme Court a cert petition in another case, but in this case, the Court of Appeals had agreed with all the other courts of appeals. As usual, I filed an amicus brief whenever this issue arises. I don't have high hopes that the court, having decided not to grant cert multiple occasions, I don't have high hopes that it will grant cert on this occasion, but I don't give up easily. So I want to turn quickly then, because I want to leave time for, of course, my colleagues and you.
Good.
Time. Quickly, my assessment. And I'll go through this extremely quickly, and that will be all. First of all, I have four major concerns. All these courts, in my judgment, federal courts, have reached the conclusion they've reached on competence without reasoning. I detect no reasoning. It's as if tribunals have jurisdiction, have been given jurisdiction, the courts have been deprived of jurisdiction. Or as the French would put it, competence has not only a positive dimension, conferring authority on tribunals, but a negative dimension, disempowering the courts. Countries around the world are divided on that question. In my judgment, American law pretty clearly goes along with positive competence, and not negative competence. But unreasoned, most of the courts have said, I agree with my fellow circuits, basically, which is inadequate in my judgment. Now, I don't want anybody to assume that the absence of negative competence deprives competence of value. There is value to positive competence. In the absence of positive competence, arguably, the tribunal would stay proceedings. Arguably, not necessarily. The UNCITRAL model law says they don't have to stay proceedings. But an American court might stay proceedings waiting for that judicial determination to take place with obviously time and money implications. So it's valuable. Let's not denigrate the value of positive competence. And to get that, you don't need negative competence. I guess I'll turn quickly to my second concern, and this is really fundamental. As you all know, competence clauses are ubiquitous. They're in every modern set of procedural rules. As I said, it's in the UNCITRAL model law, which has been adopted by over 80 odd countries. Ubiquitous meaning, of course, it's rarely not there. It's rarely not there. And what that means then is that what I read the Supreme Court as saying was exceptional is now standard. So the standard situation is now that you cannot get a judicial determination independent prior to arbitration, even if you want it, rather than go first to the tribunal. Now, that means that the first option's presumption is rendered practically meaningless for all practical purposes. That's a seismic change. Third, from a common sense point of view, if the drafters of an arbitration agreement wanted to put a provision that deprives parties of their presumed right of access to a court, if they want to make it clear and unmistakable, the last place they would put it would be buried in a set of institutional rules incorporated by reference in the arbitration agreement. We're lucky if parties read the arbitration agreement itself. They certainly don't read the procedural rules, and if they read them, they wouldn't even know what competence means. But it is on that slender basis that our courts are deprived of the jurisdiction they would otherwise have. I would say basically, allowing incorporated by reference rules to be treated as clear and unmistakable is a violation of the principle of clarity and unmistakability. It's not clear because it's ambiguous at best. And it's certainly highly mistakable, buried as it is. So the court has described what is clearly unclear and mistakable as the paradigmatic clear and unmistakable. Fourth and finally, first options was a post-award case. Let's not forget that. That means everything I have just said applies not only before the arbitration, but also after the arbitration. That means by the simple unthinking gesture of having a competence clause in a set of institutional rules, parties will have lost the so-called fundamental right that first options conferred upon them. And I'll close by saying even France allows de novo judicial review of jurisdiction after the award is rendered. I attended a conference in my last comment then. I attended a conference a couple of weeks ago in London where a revision of the English Arbitration Act is being considered. And the one thing that there was consensus about is that we must have independent judicial review at one stage or another. The Law Revision Commission was thinking about abolishing it, having deferential review both before and after, and the clamor was deafening. So we may be the only country in the world of commercial significance that has taken the liberty of depriving parties of access to a court on such a fundamental question as whether they consented to arbitrate. And all of this predicated on first options, which said what is required is clear and unmistakable evidence. I consider this to be highly destructive. I think to call it pro-arbitration is facile. I hear it constantly described as pro-arbitration. It's facile It is not pro-arbitration to enforce arbitration agreements to which parties have not consented. It's not pro-arbitration to deprive them of a right to a judicial determination on that fundamental question. It is not pro-arbitration. And it is destructive of the respect and legitimacy that I think arbitration enjoys and should continue to enjoy. Lee, I certainly ran over. I am
You're
sorry.
fine. You're fine. It was all good. It does strike me as, I'm sitting here feeling overwhelmed with guilt because I have, as a judge, done everything you have just told me is utterly without intellectual integrity or coherence. And I apologize. But Benno, and then Carolyn, do I have a choice under existing law? What can judges do? What can lawyers do? Craft arbitration agreements? What can those who oppose enforcement of arbitration agreements or awards at the back end? What can we do to counter some of the destructive forces that George has so chillingly described?
Well, dare I jump in?
Please.
Thank you, Judge. And this may not seem like the case, but actually, George and I agree on many, many things. There are a few things we don't exactly agree on. It's more a question of degree as opposed to whether there's actual disagreement or not. But let me start with this to put this in perspective. And Judge, the question that I keep asking my colleagues is what is counsel to do now, or what is a party to do now in an environment where we agree on this? The decisions of the courts of appeals all across the country are wrong. They're wrong. They are not wrong because we believe that they somehow misunderstand something that's complex. The issue is really straightforward and simple. And it's all about the words of the Supreme Court, and the words of the Supreme Court have not been applied. So that we agree on. We also agree on the fact that it is bewildering why the Supreme Court would not grant cert on one of several cases that have been presented before it, where this very issue would be put before it, and it would need to essentially affirm what was a unanimous decision in first options, where the words that it chose, we think, are really quite straightforward and simple to interpret. So we agree on that. And so what is one to do now? And so I have a few observations that I would throw out for consideration. First, it's important to keep in mind that first options is a domestic US arbitration case. It's a Chapter 1 case. Now, that doesn't take away from its importance or its applicability in the context of international arbitration that is in the United States, because under Chapter 2, it is incorporated, and the Third Circuit has already expressly done that. But it is a Chapter 1 case, and in some sense, it's the challenge, because it applies to every single arbitration in the United States, whether it's domestic or whether it's New York Convention award. Number two, there's no question that the decision in first options was correct. A non-signatory, as was the case in first options, based on a record where there is no record of any evidence presented, could not be held responsible after an arbitration for an award rendered against its subsidiary, their subsidiary, when they had not signed the agreement to arbitrate or the contract. Pure non-signatory case, there was no liability. That the decision is absolutely correct. But what I find puzzling about the case, and I think maybe this is a little bit part of the problem, is the Supreme Court didn't need to decide the case and render the opinion it rendered. This case could have been decided with one piece of paper invoking Section 10 of the Federal Arbitration Act and concluding that the tribunal exceeded its power under Section 10 and the award as to the individuals should be vacated. That's all they needed to do. The law was clear on that point. And in fact, that issue was briefed to the court. What the court decided was an issue that was not briefed. The framework it created was not proposed. And, and one of the advocates before the court in that case is the current Chief Justice. He didn't advocate for this framework, and the framework isn't needed to decide the case. In fact, the framework, you could never have clear and unmistakable evidence of a delegation of authority to decide the issue of arbitrability in a non-signatory case. You can't. By definition, they didn't sign the agreement. They agreed to nothing. They could never delegate. And so to create a framework in a case where the facts are really not conducive to elaborating on a framework that is applicable in the case raises, I think, questions about opinion drafting, let's say. But what I found, so I find that a little bit puzzling about the case itself. But the case, the words of the case, the framework that's created are powerful and they are simple. And the question the court says that's before it is exactly the issue that the courts of appeals do not understand. The Supreme Court said at the very beginning of the case that the issue before it is who has primary responsibility for determining issues of arbitrability. And on this, George and I disagree. I believe the nomenclature the Supreme Court uses is important. In the United States, it's absolutely important. And I wouldn't deviate from it one iota. And it conveys the importance of the issue that's at hand before the court, and that's of the issue of consent. And by framing the question as to one of primary responsibility, the court is acknowledging, and what the lower courts, most of which fail to acknowledge, and that is that there is, generally speaking, concurrent jurisdiction before courts and arbitral tribunals to decide issues of arbitrability. It's not either or. And even if there weren't rules of arbitration rules, international and domestic, that codified this notion of competence, I believe it would not, I believe it would be easy to argue that a tribunal, any tribunal, has the competence to determine its own jurisdiction. There is law in the international context, there's law in the domestic context. They may not, the issue is not whether they have the power to decide the issue. The question is who has the last word on the issue. Hence, the Supreme Court's use of the word primary responsibility is important. There's no question tribunals can do it. There's no question courts can do it, but the question is who has the last word. And that has been the fundamental, I think, misunderstanding of the lower courts. For some reason, there is an inability to understand that an arbitral tribunal, when a challenge is made to the tribunal's jurisdiction, has the power, has the right, maybe has the obligation to determine that issue. But that says nothing about whether or not that issue can be reviewed independently by a national court when that award is brought for vacatur under the Federal Arbitration Act or set aside under the New York Convention. And so that's really what I find most troubling. What's interesting, and George alluded to this, is that the most searching and thoughtful jurisprudence in this area comes out of state courts around the country. California, Texas, Florida, Montana, and some of the best decisions are not the Supreme Courts of those states, but the intermediate appellate courts. And they're thoughtful. They follow first options. They ask the question, they follow the words. Something the federal circuits have absolutely failed to do. And just to show you how inexplicable this is. There's only one federal circuit, the Sixth Circuit, which decided a case. It's the Blanton case in 2020. Until 2020, no court of appeals had even engaged in trying to explain why they thought that adopting arbitration rules somehow was a delegation. And in this case, the author of the opinion wrote the following, which tells you a lot about the level of understanding. So it reads as follows, and this is meant to be persuasive for why the outcome is correct. It reads, quote, most people who read the sentence, quote, the arbitrator shall have the power to rule on his or her own jurisdiction, close quote, wouldn't then think, but a court may also rule on this issue. And things would get pretty chaotic if the rule were read this way. It would lead to a race to the courthouse or arbitrators forum to have each party's preferred decision maker be the first to rule on the issue. For if a court ruled on the issue first, then that ruling would bind the arbitrator under the doctrine of res judicata. Well, not terribly persuasive, but it ignores the very question the Supreme Court considered, and that is who has primary responsibility. The issue is not who has exclusive responsibility. And so what is one to do? And this is just a couple of thoughts. Some of us have thought that filing amicus briefs in the Supreme Court was a way to get the court to revisit this question. Does it want to change the first options rule? Because that's what the courts of appeals have done. They've essentially negated the rule. So far, that hasn't worked. Is there anything one can do in the circuits? Well, now, what is it? 10 out of 11 have ruled, have basically read first options out of the law books, and they're not going to revisit the issue. Under their own rules, they rarely grant in-bank rehearing, and there's no reason for them to do it. This has been on the books now for years. And their view is if they're wrong, the Supreme Court will fix it. Well, the Supreme Court hasn't taken a case. And so, it's interesting that I think in some ways the states have shown themselves to be the more faithful to first options, more understanding of the framework, and more willing to sort of buck the trend. But it is a perplexing problem because our system doesn't have an easy way to correct other than the court granting cert, which it so far has been unwilling to do.
And that cheerful note in which you have told me essentially that I am helpless to better myself or put the law on a different track than it currently occupies. Carolyn, you are deep in the practice.
I am deep in the practice.
How do
And
you,
I
tell us
always,
how that affects your thinking on these issues.
I almost always agree with George and Benno. But George and I have debated many things in the restatement process, but come out in the same place, along with the judge. And, this is an exceedingly difficult area because I think lawyers and judges have conflated a lot of concepts that they really need to tease apart in terms of fundamental tenets of US law that motivate a little bit of a different approach to the end result. Now, there's no question, certainly under BG with the issue we started with on arbitrability, it's the whether. And that's the same as the first options analysis, whether under the clause, this is subject to arbitration. And of course, that is where you, in fact, introduce many issues. I am heartened a bit by a recent Second Circuit decision, a small bit, but a bit, the DDK Hotels versus Williams-Sonoma, because at least there's some granular reasoning as to the different legal policies and the decision-making around the arbitrability issue. In that case, it's relatively simple and straightforward. There was an arbitration clause. It did refer to AAA rules, but it only permitted the arbitration of a single issue if a board came to an impasse with respect to certain board decisions. So it was a very narrow arbitration clause if there was a deadlock on the board, and they had equal numbers. But the interesting thing is what the Second Circuit did with it. And this is it's an April case, a relatively new case. And the Second Circuit didn't automatically say, you mentioned the AAA rules, you're out of here. Not at all. In fact, analytically, I thought it was quite strong because they start with the fundamental tenet of law that by agreeing to arbitrate, a person doesn't surrender their right to the courts. And in determining whether arbitrability of a dispute is to be resolved by the court or the arbitrator, the arbitration agreement is determinative, referring to first options. And they then, in fact, take apart the language of the clause and actually apply what I think to be a fairly careful analysis. They require, of course, as first options did, clear and unmistakable either delegation or language in the clause. And they say that for the court to assess this, we have to apply the regular interpretation principles that one does in examining language in the formation of a contract to assess the party's intent. So they didn't just take by reference the AAA rules, competence, as excluding their analysis. Now, certainly it was a very narrow, but at least they analyzed it. I've seen less in other far more important cases. And they came out saying that under the terms of this arbitration agreement, therefore, they did not feel that the implicit or explicit reference to AAA rules was dispositive or evidence of any clear and unambiguous consent, so that functionally and analytically, they took this granular step that they should have taken in terms of assessing whether or not that particular arbitration clause reached and involved the consent of these parties. And I think what we have are a number of competing legal interests, policy interests in the way the courts have been approaching this. And we really have to, in a very pragmatic way with evidence and things like this case, begin to push. I agree, of course, that if we could get the Supreme Court to accept cert and rule on it, maybe there'd be a change, but one doesn't know. This is not an activist Supreme Court, to be sure, except where it wants to be on issues of social justice. But putting that aside, on arbitration issues, I don't cling to them as the great hope in our future. We better think about ways to make a little progress like this in the districts and circuits with well-thinking judges.
Lee,
You mean
may-
judges who have attended this conference?
Lee, Lee, may I just say one word?
Please.
Before we open things up, actually, it's a couple of words. First of all, I hate to disappoint you, Benno, but of course I don't disagree with you. I said parties have a right to a judicial determination if they wish instead, initially, they can choose. So we're in full agreement on that. Secondly, of course, Carolyn, you know better than virtually anybody else, that the way to get this problem fixed is through the restatement. So I have to add, and Lee is very involved in the restatement. This is the only issue in the restatement where the ALI has taken a position contrary to a position taken by every federal court of appeals. Now that's going against the tide. To do that kind of thing is frowned upon on the part of the ALI, if the ALI does that kind of thing. But we actually got that through.
Yes.
And you know, Carolyn, you know how rare that, it is for restaters to say, I disagree with every federal court. I disagree with every federal court, and we read everything otherwise.
Right, and black letter and with good reasoning in the advisory committee notes. So, maybe the courts will listen.
Well, so Judge, in answer to your question, what could someone do? I think what we need is a courageous federal district court judge who, when presented with the arguments that the law that's on the books all predates by, in some cases, decades, the restatement, and predates some of the thoughtful opinions of various state court judges around the country, and that in fact when one basically goes back to the words of first options, the Court of Appeals decision is contrary to the words of the Supreme Court, that the Supreme Court laid out the law and it's not been faithfully adhered to. If that were to happen, and in other contexts, historically, that has happened. That's how it's gotten before the Court of Appeals again. What would the circuits do? I mean, I don't know, but I think presented with a thoughtful, comprehensive opinion, the circuits would have a circuit would have to take a very careful look at what they've done.
Lee, don't feel any pressure.
Well, I feel both pressure and a sense of the triumph of faith over experience working here. But faith is good, hope is good, and this is a wise path. So to those of you in the audience who are lawyers, cite the restatement to the courts. And those of you who are judges, cite the restatement in your brave opinion and invite the courts of appeals to look again at some issues that would otherwise perhaps be viewed as foreclosed. I can see the words reversed looming on the horizon, but that perhaps is where it has to begin. And of course, to make an obvious point, all of this work that the panel is inviting lawyers and district judges to do is expensive. It is time consuming. And it therefore undermines, at least deteriorates, some of the reasons that are touted as important for arbitration in the first place. Reduced cost, reduced time. All we're doing is creating more cost, more delay, and more work for mother, which is me. One of the interesting things that came out of your exchange is this notion of context matters. Tell me what you mean by context, what evidence of context is needed? Not evidence of whether the parties have consented or not, but evidence of the context that will shape the way courts view whether there has been consent. And perhaps, Carolyn, will turn to you first, and then Benno, and we'll give George the last word.
Well, that's right, George. Context does matter, and that's what we've seen emerge in the DDK court's analysis. What they looked to was the joint venture agreement between the two parties and exactly what that informed in terms of the contract formation, the formation of the arbitration agreement. And one could look at, and I've argued this recently in two sets of cases in DC, one for India, one for Russia. And in both cases, looking at whatever the arbitration clauses are found in, of course, the agreements, but also the exchanges at or about the time between the parties, creating the circumstances of the agreements. I do think applying principles of contract formation in certainly commercial or treaty cases to discern intent. And even in treaty cases, of course, you have the assistance of the Vienna Convention in terms of interpreting the words, but they aren't far off from standard interpretation provisions. And so the context is how the parties, what they understood in the relationship between competence, if they understood anything, and judicial review, and how it's understood at the place of arbitration. I don't think you dismiss when parties choose a seat, the lex arbitriat, the seat. You don't, and that may be different. And some of the arbitration clauses in today's world are incredibly complex, and you have a reference not only to the lex arbitriat, the seat, not only to the rules, not only to the FAA or law applicable, et cetera, so that a reference to the rules, the procedural rules that you're going to use under such a clause, and I have one now in the 11th Circuit in the Panama Canal arbitration, that is incredibly complex. You can't say that by choosing a particular set of rules, ICC rules with competence, you've excluded when there are 6 other sources of law referred to, that is the sole determinative access to the courts or for what the arbitrators ought to be doing. And it certainly cannot be dispositive when you're then there on a set-aside petition, because the rules on set-aside, depending if you're in an UNCITRAL model rule or if you're, in Florida, you do use New York Convention, but Article 5, but it's effectively the same as UNCITRAL Chapter 34. So you really have many other sources of law that the courts must look to in such a complex clause. It is not good enough to give it the back of the hand and say, that's it, it's over, you selected ICC or AAA rules and they have competence.
Mhm.
That's not
Does this
correct.
analysis, to the other panelists, does this analysis of context and how it matters change if the arbitration provision is in a consumer contract or in particularly a consumer contract in which one enters the contract by checking a box or by doing nothing except agreeing to purchase?
Well, Lee, the case before the court right now on cert petition is a consumer case. And if you read the pleadings, you're struck by the degree of emphasis that is placed upon that feature of the case. All the rest is also there. All the analytics that we've been through is in the pleadings. But it's sort of, and what's worse is, what's intolerable is that this is a consumer contract. And the consumer certainly didn't read the rules of procedure incorporated by reference, nor did its lawyer in all probability.
Well, and in many jurisdictions, I'm sorry to intrude,
No.
but in many jurisdictions, unless it's specific, consumer contracts may not be arbitrable. Public law contracts may not be arbitrable. Tax disputes may not be arbitrable. There are many on the basis of the law of the seat, you can't arbitrate.
Are there any criteria that distinguish issues that simply can't be arbitrable, can't be arbitrated, from those that are eligible to be considered for arbitration? How can we tell going in?
The received wisdom is, and the best that's been said, is that if the issues involved in the claim implicate sufficiently fundamentally a public interest, then a governmental adjudicator is more appropriate than three mortals
I really like a
who
bright line,
happen to
clear
have been
test.
named arbitrators in that case. I can't do better than that. As a practical matter, in the United States, but this is how our Congress works, we never think, Congress never thinks systematically about what should and should not be arbitrable. What we declare when Congress declares something non-arbitrable, it's usually in the wake of some scandal. So some scandal has occurred and sympathy is aroused and that claim becomes non-arbitrable. But one would think that the ideal legislature, in addition to adopting a law, deciding who has standing, what the remedies are, what the statute of limitations should be, is whether the damn thing is arbitrable.
Mhm.
And that is the furthest thing from the agenda of congressional committees.
But the point, Judge, I think today in the United States is that absent Congress expressly providing that something is not arbitrable, the breadth of the Federal Arbitration Act would lead to its being arbitrated.
Right, right. Which is at least a clearer standard than the, is this matter sufficiently intertwined or implicating public interests, fundamental public interests, so as to be not arbitrable? That's a pretty squishy standard.
Yeah.
And courts engaged in these issues resist squishy. Consent is inherently squishy.
That's why we go with scandals.
I'm waiting for a good one in this context. So we have a very few minutes left, one to be precise. But I'd like to use it to invite any questions from the audience, many of whom are experts. I see one hand, and I can't see whose it is, but please. Go ahead.
Is the microphone on? So Frances Bivens from Davis Polk. I'm on the next panel, but I've worked with George and Benno on these first options issues many times. And my question is whether there is a legislative solution and whether you could propose an amendment to the FAA to actually address the issue. And the reason I'm asking is that I'm wondering if it could also address the procedural question that I think challenges the courts when these issues arise, which is that the issue of arbitrability in many of these cases gets raised 7 years into the arbitration. So the arbitration has been pending for a number of years. It's then gone through the courts for a number of years after that. And the court that's deciding the ultimate issue is faced with the inefficiency of what it would mean to decide after all of this time that the original panel that heard the case, in fact, didn't have jurisdiction. And I'm wondering if it were legislated and it was the subject of an FAA amendment, whether you could also address the timing question of when, if you were going to go to court, it would need to be done. So it could be done in a more efficient way that wouldn't require the relitigation of a very extensive arbitration.
I'd give that to any member of the panel who wishes to go first.
Well, I will, being shy. You know, there are manifold, myriad ways in which the FAA could be amended to address the issues that have arisen. But it's a 97-year-old statute. Congress has no appetite for this. And I don't think it's going to acquire an appetite for this. You don't get reelected because you sponsored this thing. So I'm not particularly hopeful. Other people have said, and I'm not one of these, that we shouldn't reopen the FAA because Congress will make it worse. I actually think that's not possible.
Let me comment on that. We're soon approaching the 100-year anniversary. In 1925, when the FAA was enacted, that's long before we had a New York Convention. It's long before most countries around the world had an arbitration law. The record of this country based on the FAA, it's a short statute, very short. In many ways, it's served very, very well. And, you know, I personally, if you ask me, do I think Congress, I do not believe Congress could possibly do any good if it were asked to do anything. But you know something, I don't think it takes the courts off the hook to apply first options as the Supreme Court in a unanimous decision articulated it. And I think that's where the effort needs to go.
But Francis, you raise many more issues than the ones we're talking about today. I think your question was, you gave us some illustrations. So first options, you're right, this is for the courts to fix. But there are, as you said, so many ways in which the FAA is unresponsive to the issues that are real in the practice of arbitration.
And on that note, yes.
One fast comment, certainly on the occasion, the 100th anniversary, the bar could come forward and following the restatement, make proposals and very specific legislative proposals for updating that could be adopted. I'm afraid, and I don't want to point any fingers at anyone in particular and won't, but I'm afraid we can't rely on the arbitrators. They seem to have always the incentive to fold the jurisdictional issues into the merits to decide at a later time in the proceeding. And the judges are hampered, in fact, by both that approach, and they're left with a mess at the end when you're on a set aside and you look like you're trying to get out of a bad decision that should have never been there in the first place. So all of the incentives are wrong to have it come from the major players. If it doesn't come from the bar and academia, I don't know who it will come from.
I'm feeling the pressure once again. But it would be a shame to let a centennial go to waste.
Right.
It should be exploited. And I hope that all of you who are gathered here today will do so. It's worth doing, as our panelists have made clear. Please join me in thanking this wonderful panel. And I think we are ready for the next panel.
I think we had one more question from
Oh, I'm
Professor.
sorry, I can't see
Oh,
that.
hi. So just quickly, first of all, George, the FAA was just amended last year per George on the scandal side in terms of in terms of dealing with the Me Too and sexual harassment and assault. And second, Senators Blumenthal, Leahy, we have a long tradition from 2007 or before of senators offering to respond to Judge Rosenthal's point, the exemption for civil rights and the like. But third, and most sort of as I'm listening to your wonderful overview, I'm just hearing how every one of us who is not a large-scale participant in an arbitration is treated, because no one gives a damn about my consent. I buy any good service, go to a nursing home, have my cell phone and my credit card, and I lose all of my access. So it seems to me you've offered an amazing cross-class opportunity with the stunning capacity that you all understand the real arbitration to be, to take the anniversary, take NYU, and do a major, and the ALI, and try to retrieve the concept of genuine consent and the integrity of arbitration. All the courts of appeals are just doing what the US Supreme Court did since 1995 forward. That, I'm sorry, First Options is a huge antique because this is how everybody else is treated. So my question would be how to marshal your understanding and your commitment to arbitration to retrieve it.
I find it very tempting, but the restatement took 13 years. So
And
as
many debates.
Carolyn knows only too well. But in the abstract, I think there's nothing I'd rather do. I mean, professionally.
All right, we are over time, but did you want to comment, Carolyn?
No,
Oh, okay. All right. Thank you very much. I'm going to call this panel to a close. We appreciate it. Thank you, Judge Rosenthal. Feel
Oh,
better.
it's a pleasure. I'm going to mute and stop video, but I will be present.